So next is Article 21 capital A, which is what? Right to education. So article is important. When was this article added is important. So this was added through the 86th Amendment Act 2002. Okay. So the state shall provide free and compulsory education to all children of the age 6 to 14 years in such a manner as the state may by law provide, and the state has made a law. The law is this: Right of Children to Free and Compulsory Education Act 2009, RTE Act 2009. Okay. Also important to note is that, with this 86th Amendment Act, 3 changes were made. So please keep a track of all those 3 changes. Number 1 was, of course, a new fundamental right was added. Number 2, there is a DPSP called Article 45. This has been modified. Okay, so earlier the DPSP contained this line that the state shall take steps to provide for education for children between 6 to 14. Now we have modified that, and we now say that the state will endeavor to provide early childhood care and education for kids up to 6 years. So earlier it was 6 to 14 here. Now we have made this into a fundamental right, and here we have changed it to 0 to 6. Are you clear? And also with the same Amendment Act, one more article was added, that was a fundamental duty. So Article 51 capital A is the only fundamental duty. And in that there is a subclause K, which was clause K, which was added. Duty of every citizen who is a parent or a guardian to send their kid between 6 to 14 to school. So single Amendment Act, 3 different parts were also modified. Part 3, Part 4, which is DPSP, and Part 4A, which is fundamental duties. Okay. Next is Article 22. That's the last article under right to freedom. This article gives us 3 rights. Number 1, right to be informed of grounds of arrest. Okay. Number 2, right to consult a legal practitioner. Number 3, right to be presented before a judicial magistrate within 24 hours. Clear? Remember, these 3 rights are provided to us. Now, this kind of right is not available to 2 categories of people. One, those who are enemy aliens. Who are enemy aliens? All those people of any country with which India is officially at war. Okay, so for example, say Pakistan, China, etc. Citizens of these countries, are they enemy aliens? No, they are not. Because we don't officially have war with them. If we officially declare a war with Pakistan, then Pakistani people become enemy aliens. Are you clear? It's conditional. And second is all those people who are arrested under preventive detention laws. So what is meant by preventive detention? So normally you commit a crime and people, the police might arrest you, but preventive detention means before you commit a crime, you are arrested. Okay. Like, very simple to understand. How your mom, if she is leaving your house for a couple of hours for some work, she'll thrash you before leaving the house so that you behave properly. You're not committed any mistake, but she wants to discipline you so that once she leaves, you don't commit a mistake. Preventive detention. Okay. Now, preventive detention can be done on these grounds: security of the state, maintenance of public order, maintenance of supply of essential services, and foreign affairs or security of India. But you have to make a law for it. Okay. And who can make a law on preventive detention? Both center and states can make a law. Why? Because preventive detention is a union list topic and it is also a concurrent list topic. So let's not forget, both center and states can make laws on matters of preventive detention. Are we clear? Okay. Now, once you are arrested under preventive detention, then what happens? Then in that case, you can be arrested for maximum how many months? 3 months. And within those 3 months, then you are taken to an advisory board. Judicial advisory board. All of you have the fundamental rights note copy. Everyone else has the fundamental rights copy, this one. So if you are under preventive detention, you will be kept for maximum 3 months. You can just underline this, it reminds you there, 3 months. And then you are taken to an advisory board which can advise further arrest. Are you clear? That's it. This is all that is required to be known for preventive detention. Though we have various examples of preventive detention laws, and a very good example of a preventive detention law is National Security Act, NSA 1980. It's a very popular law under which people might get arrested, and that's a preventive detention law, meaning you have not committed a crime, but the police will come and arrest you. Normally, if you raise any concern or criticize the government, that law is used against you. That's the idea. And then we have very good examples like POTA, POTA, Prevention of Terrorist Activities or Terrorism Act, POTA 2002. This was passed in the aftermath of the Parliament attack, that Afzal Guru attack that happened in the Indian Parliament. So then this law was made, but it has been repealed also. It was made in 2002 and repealed in 2004. So POTA is a very unique kind of law. So yesterday we were discussing Article 20, remember? No self-incrimination is a part of Article 20. You cannot be forced into being a witness against yourself. Police cannot force you into giving a confession. But and I said that, if you give confession in front of police, that cannot be used in court. Yes or no? Remember? But under POTA, if you give a confession to police in the presence of an SSP ranked officer or above, that confession can be used in court. So when the police is beating you, they should have an SSP officer in front of them and then beat in front of them, then there is no problem, which is very draconian in nature, because SSP is not some God's gift to mankind, right? They also have the same kind of bias. So that could be a problem. Thankfully, POTA no longer exists. It has been repealed, but governments are smart. When they repeal POTA, a lot of these provisions of POTA were brought into UPA. So POTA is still there in a different form called UPA. Though UPA is an old law, but they have been amending UPA and they have been slowly and steadily taking all the elements of POTA and they put it in UPA. So we don't even come to know. And the law still continues. That's the beauty of our government, smart people. So that's there. This was Article 22. Now, next two articles are 23 and 24, right against exploitation. First one is Article 23. Article 23 is the article which talks about prohibition of traffic in human beings and also no forced labor. So any kind of traffic in human beings and begar and other similar forms of forced labor are prohibited. What is begar? Begar means compulsory work without any kind of money. That's called begar. When your parents ask you to bring vegetables from the market, fill the fridge with water bottle, that is begar. Okay? Refuse it outrightly. Article 23 getting violated. They might slap you and all, but that's risky. Risk is yours. Second is forced labor. When you compel someone to work against their will, like you have been forced by your parents to come and sit and prepare for UPSC, that is not begar, that is forced labor. Difference. So this is what you are doing here is forced labor and otherwise begar. Are we clear? Now, since all this is not allowed, it can be punished with a law. We have a law already in the country. There are various laws. For example, there is a law called Bonded Labor System Abolition Act. That's a very popular law. One more law, since traffic in human beings means what? Buying and selling of people. That's called traffic in human beings. It also means immoral traffic in women and children. That is prostitution. Devdasis and not slavery. Devdasis and slavery. Now to prevent prostitution, we have this law called ITPA, Immoral Traffic Prevention Act. Originally, this law was called Suppression of Immoral Traffic Act, but the name was changed because, this name is not good. If you look at the abbreviation of this name, it is SITA, Sita. It's named after a Hindu goddess. So we did not like this. We changed this That's the only reason it was modified. So now we call it ITPA, Immoral Traffic Prevention Act. Okay. So these things are also important to governments, that an abbreviation is perfect. Especially this government. This government is obsessed with abbreviation. They create all these things out of thin air, unique abbreviations. Ji Ramji. So that's how it is. So this is Article 23, but very important to understand that second clause allows the state to enforce what? Forced labor. Nothing in this article shall prevent the state from imposing compulsory service. So state can impose compulsory service for public purposes. Okay, this is allowed only for the state. For example, a lot of these countries have something called conscription. You know what is conscription? Military service, which is compulsory. That's called conscription. Like in our country also, you have a lot of these things. Voting, election duty, for example. All bankers, all teachers, it is mandatory for them to serve under election duty. If they don't, arrest warrant can be issued against them. That's also a forced duty only, though they get money for that, but still. So conscription is military service. Lot of countries have it. Algeria, Cuba, Iran, Israel, South Korea, right? All those BTS boys, when they were being forced into go to military service, Indians are very upset that don't send those cutie pies to military service, etc. But that's the rule of the country. What can we do? Now, here also it is important to understand that the state can impose compulsory service. This compulsory service can only be done by law, not through a government order, because restrictions can be imposed only through laws in the country. Okay. And one more thing, if you want to impose any compulsory service on people, you cannot discriminate on 4 grounds: religion, race, caste, or class. This means tomorrow, okay Ankita, we'll tell them to send the PPTs beforehand. Okay. Because it was sent 2 days back. I'm surprised it is not received yet, but we'll see. So, religion, race, caste, or class. As I said, let's say government enforces compulsory military service in India, that everybody has to serve in the armed forces. So they cannot do this only for Hindus or Muslims or Christians, because no discrimination on religion, race, even caste or class. So only rich people have to serve or only poor have to serve. This cannot be done. Only men have to serve. Can this be done? Yes, it can be done, because gender is not mentioned here. So only men, only women, please be aware, it can happen in future that only men or women will have to serve. Clear? Okay, so this is Article 23. Next we have Article 24. This is no child labor. So the article says no child below the age of 14 years, I'm sure all of you are above 14 now, so shall be employed to work in any factory or mine or engaged in any hazardous employment. Okay, so when we say hazardous employment, it actually means 3 things: mines, explosives, and inflammables. Any industry which deals with these three things, that is known as a hazardous industry. Okay, if you want bangle making, iron ore, coke, etc., right? These are all hazardous industries. If you want to know the list of all such factories, you please download the Factories Act 1948, look at their Schedule 1, list of all the names of such places are mentioned there. Okay, where kids under 14 are not allowed to work. Now, some points are very important to understand. Again, we have a law made in 1986. That law is called Child Labor Regulation and Prohibition Act. This law is the one which bans child labor. Clear? And one more misconception is that, a lot of people I'm sure would not be aware. In our country, can we employ kids as house help, domestic servants, we cannot employ them. Okay, since 2006 only, it is not allowed. So if you are employing a kid, then it's a punishable offense. Okay, and the punishment can range from fine of 20 to 50,000 and jail of 6 months to 2 years also. Per individual employed, you will be asked to pay a fine of up to 50,000 rupees if you're a repeat offender. Okay, so punishment is very strict. And also please understand that once you pay the fine, you're not allowed to continue the employment. Okay, up to 50,000 up to 2 years. I'm including the maximum punishment here. That's the maximum, which means for repeat offenders. Once you employed a kid, you were punished. Again, you did not improve, again employed a kid. Then for repeat offenders, this is the maximum punishment. Otherwise, for first timers, this is 20,000, this is 6 months. Clear? So in 2006 itself, this law was amended, banned employment of children as domestic help, and in roadside dhabas, tea stalls, spas, hotels, restaurants, it has been banned since 2006 itself, 20 years. So if anybody is employing such small kids, please stop the employment immediately, or else complaint can be issued against you. That could be a problem. Now in 2016, this law was again amended, and this time we put a blanket ban. Kids under 14 cannot be employed in any sector. Are we clear? Anything. There are only 2 exceptions. Exception number 1 is a family-run enterprise. Let's say some person is running a vegetable shop. After school hours, the kid can help the parents. And here, family is very strictly defined. So it's parents, unmarried sister, brother, etc. Family does not mean uncles, 14th cousins, 13 son-in-laws, 14 buaji, not all that. Distant family, not covered. Okay, very close family, and that too after school hours, not during school hours. And number 2, audio visual entertainment industry. You know, all these dance junior, sing senior kind of programs, Indian Idol and all, KBC. So in these kind of programs, you remember that KBC's Tushar, what is the guy? Tushar? Ishan. Do you remember Ishan, that fellow, that crazy fellow who lost completely? That kind of situation. I mean, he deserved it, but... So, audio visual entertainment industry. So, kids have to be employed here, because then kids can bring in TRPs, right? They'll come there and they'll cry, I come from poor family, etc. Then TRP ratings soar. So, we have to have kids here. So, only 2 places. Number 1. Number 2. Otherwise, under 14 kids are not allowed to be employed anywhere. Clear? There is one more category now called adolescent, 14 to 18. This is a new category created in 2016. These people can be employed in every sector except hazardous occupations. Meaning which 3? Mines, explosives and inflammables. Inflammables are things that catch fire quickly, so any kind of industry. So, any adolescent here? Of course not. You're all above 21, hopefully. So, but if you have your younger siblings and all, please don't force them into hazardous occupation. Okay. That's about it. Articles 23 and 24, right against what? Exploitation. Now, next set of dangerous rights from Article 25 to 28. This is a freedom of religion. So, Article 25 is the freedom of religion for individuals. Please look at the restrictions here. Public order is a restriction. Morality, health, other provisions of this part. Okay, every other provision of this part. Which part? Part 3. We are discussing part 3 right now, fundamental rights. So every provision of part 3 is a restriction on your Article 25. Are we clear? Okay, so Article 25 is the lowest in the importance of fundamental rights. This is the least important fundamental right. Now what right do we have? We have these 4 rights. All persons are equally entitled to the freedom of conscience and right freely to profess, practice and propagate religion. Conscience meaning what kind of relationship you want to form with God. You talk to God, God comes in your dreams. You believe God is in books, you believe God is in UPSC, you believe God is in your parents, you believe God is in somebody you love, tujh mein rab dikhta hai type thing. It is all your drama. Nobody cares about all that. Clear? Feel free to mold your inner relationship with God in any form you want to. Okay, that's called freedom of conscience. Second is profess. Profess means to proclaim. So there are a lot of visible manifestations in which we can proclaim our religion. For example, somebody can wear a skull cap, somebody can wear a burqa, tilak, turban, etc. All that is allowed. You can freely proclaim your religion depending on circumstances, okay? People around you also. Be careful. You might end up in a dangerous situation, but yes, you can proclaim or profess freely your religion. Clear? Then you can practice your rituals, carry out all the dramas that you want to, nobody cares. But please, public order, morality, health should not be violated. Any ritual that affects these things and other fundamental rights, that ritual has to be stopped. Okay? And then you can also propagate, spread your religion. Clear? Please understand, propagate does not include right to convert. So you can propagate your religion, but you can't convert people if the conversion is obtained via three things: force, fraud, or allurement. On these grounds, you can't convert people: force, fraud, or allurement. Otherwise, it's their choice. If somebody wants to convert, nobody cares. But in most states, we have anti-conversion laws. You have to give prior notice before conversion to the local district magistrate, SDM, depending on the law. Okay, so you can't convert as freely as you think you can. Officially, if you want to. Otherwise, in your mind, no problem. Especially before the exam, you believe in all the gods, right? Whichever God helps you clear the exam, no problem. But if you want to officially convert, you have to inform the state government in most of these cases. And you can't use these grounds to convert people forcefully or fraud, maybe through on the pretext of marriage, etc. You marry and then you force them to convert. Emotional blackmail. You know emotional blackmail? Parents' favorite tool. Emotional blackmail. That same thing. And allurement. We don't know what is the meaning of allurement actually. Allurement means to lure somebody. Possibly maybe giving money or telling them that please join my gang, join my religion. Once you join, you can clear UPSC. Then you might join any religion because UPSC is important. That could be allurement. These words are not defined anywhere, but that's the idea. Also, in the constitution, so see what is meant by professing your religion, publicly proclaiming it, right? So for example, as a Hindu can wear a tika, a Muslim can wear a skull cap. Those things are mentioned. But my point is that that is not a guarantee. We can't assure you all that. One thing that is a guaranteed or assured protection is this: the wearing and carrying of kirpans by Sikh people. Kirpan is like a knife. Sikh people are allowed to carry a knife, okay? And that is a part of their profession of Sikhism. So you will have to allow a Sikh person to carry a kirpan everywhere. Of course, they won't carry a machete, big weapon everywhere. They'll carry a symbolic plastic knife possibly, because carrying a knife is a part of practicing their religion. Clear? That's the only thing that is mentioned in the constitution. So tomorrow if some Hindu claims that I have a right to wear a tika or a Muslim claims they have a right to wear a burqa, we'll have to justify it. Show me the religious texts, how it is justified. The constitution does not offer protection like this. Are you clear? That is why all these cases are pending, whether hijab is a part of Islam or not, etc. Because only one thing is protected, and that is for Sikh people carrying a kirpan. Clear? Other things don't have the protection. Now this is important. This is Indian secularism. I think when we were discussing secularism, we had mentioned this term, principled distance. Okay. So see, you enjoy all these rights, but nothing in this article shall affect the operation of any existing law or prevent the state from making any new law to regulate or restrict any economic, financial, political or other secular activity. And very, very important, state can also provide for what? Social welfare and reform. That is why the state can make laws and interfere in your religion. So this is something that it is allowed for the state to interfere in your religion freely. Clear? So for example, we had a triple talaq law which was made banning triple talaq. The state interfered in the Islamic practices. Why? Article 25 clause 2. We can provide for welfare and reform. And what is the meaning of state? Article 12. The definition of state under Article 12. Okay. Or throwing open of Hindu religious institutions of a public character to all classes. So Hindu temples meant for all. And here in the constitution, Hindu is defined as Hindu, Sikh, Jains and Buddhist. Normally, for various situations, the definition of Hindu might vary. For example, a scheduled caste person can only be a Hindu. And there Hindu means Hindu, Sikh or Buddhist, not Jain. So an SC person cannot be a Jain. Clear? But here, Jains are also covered under Hindus. For the Hindu Marriage Act purpose, all are covered, but Sikh people have their own Marriage Act also. But for this purpose, all these four religions are a part of Hinduism. Indic religions basically, all those which grew in India, which were formed in India, they're all offshoot. Let's not make any controversial statement, but largely since Sanatana was the oldest religion, so all these came from those religions only in a slightly modified version. That's about it. Article 25. Then we have Article 26. This is a group right given to religious groups. 4 things: you can establish and maintain institutions for your religious purpose. Number 1. Number 2, you can manage your own affairs in matters of religion. Number 3, you can acquire and own movable and immovable property. Very, very important. Individuals, citizens don't have a fundamental right to property. Okay, we know it. It was repealed in Article 19. Yes or no? But religious groups, they still enjoy a fundamental right to property. This is the right that they enjoy. Are you clear? We don't enjoy a fundamental right. Our right to property is now a constitutional right only. Article 300A. But they enjoy a fundamental right to property. Difference. This was the provision which was being questioned in the Keshwanand Bharati judgment. When the temple land was taken away in the Ednir Mutt for Keshwanand Bharati, he was a priest. This was being challenged. Clear? This is Article 26. Very easy. I mean, we don't really expect questions from these provisions because we have not seen questions from these provisions so far. Then Article 27. So just sorry, yes.
Related to this, to own and acquire movable.
Then we also have to administer such property in accordance with law. So you can administer your property, but state can make laws and regulate the administration. Okay. So Waqf board, yes. For example, so the state can make a Waqf act and regulate how you control the property. Clear? And there are some issues with the Waqf because of the claims, etc. This is largely meant for religious groups. Let's say a mosque or a gurudwara or a temple has some land. It is your land, no problem. But then there are so many layers to this very general statement that most of the temples in our country are controlled by government. Government makes a board and then controls the temple, appointing its own members in the board who then control all the money of the temple, which is a very strange thing because any person who believes in the temple, he comes and donates money to the god, not to government, and the government can take the money. Okay. Then for the Waqf thing also, again the claim is that it comes from the Quran also, that any land that once has been claimed by Muslims, it continues to be their land. So those are largely property issues. Okay, those don't fall truly. Waqf does not truly fall under this category. It is largely meant for a temple, mosque, etc. Okay, Waqf is more of a land dispute because Waqf land is not a land where there is a mosque always. A land owned by Muslims. Okay, so we cannot truly cover that here, but nevertheless, it is not that you have an unrestricted right to temple property or mosque property. Your administration of property will be done through laws. You can manage your property, but through laws only. Are you clear? That's the idea. Then come to Article 27. In short, if you remember your medieval India classes, jizya, remember? So on all the non-Muslims are called zimmis by these invaders. So all these non-Muslims were forced into paying a tax, religious tax, protection money, hafta wasuli. Like in Bombay, you have the bhais claiming extortion money, same kind of thing. Such kind of taxes will not be imposed on people. That's it. No person shall be compelled to pay any tax, the proceeds of which are specifically appropriated, taken in payment of expense for promotion or maintenance of any particular religion. This means there won't be a religious tax that Hindus or Muslims have to pay a special tax, and the money will be used only for promoting one religion. But just to clarify, government can use some tax money to promote all religions, which it does also. Be it, running all these spiritual pilgrimage kind of drives, or improving the Amarnath Yatra, giving salaries to Muslim imams in all these madrasas. Various states have state-run madrasas, okay, where the imam is on state government salary. Gujarat, Bihar, West Bengal, various states, your state also. Clear? So those things are there. But we will not be forced into paying a Hindu tax or a Muslim tax or a Christian tax, Sikh tax. That will not be enforced. Are you clear? And lastly is Article 28. So Article 28 talks about teaching religion, or not religion, but teaching rituals in schools and colleges. So there are three types of schools and colleges, which is educational institutions. Number one, any school or college which is owned and administered by the state. Any kind of instruction. What instruction? Religious instruction is not allowed in these government schools and colleges. Okay. Number two, any school or college which is recognized by the state, meaning, they get accreditation by the state, CBSE, etc., ICSE, etc. So there, religious instruction is allowed, but with parents' consent. And if you are above 18, then with the consent, with your consent. Okay? And please understand the point of difference. I am talking about religious instruction, not teaching of Jesus Christ or Prophet Muhammad or Lord Ram, Mahabharata. Those are moral science classes. If there is a chapter on Guru Nanak in your classroom, that is a moral science class. It is not a religious instruction. What I mean by religious instruction is, if you are being taught how to perform a havan, how to offer a namaz, that is called religious instruction. That will not be allowed. You can't claim that somebody is forcing me to go through this chapter on Mahabharata, etc. Why? That is a moral science class. Are you clear? Third, those schools and colleges which are set up by religious denominations and charitable trusts, missionary schools, madrasas, etc., their instruction is allowed. This means that school or college can enforce religious instruction, and you will have to study also. If you refuse, please leave. Are you clear? But in government colleges and all, it is not allowed. That's the long story short. This was Article 28, freedom of religion. We have not had a single question from the entire topic, Article 25 to Article 30 so far in the last 25-30 years. Not a single question. So don't go too crazy for this. Then these two, we are back to rights only meant for citizens. Okay? 5 rights meant only for citizens: 15, 16, 19, 29, 30. 29 and 30. Cultural and educational rights. So here, any section of citizens residing in the territory of India or any part having distinct language, script or culture, they have a right to conserve their language, script or culture. So you can conserve your language, conserve your script, conserve your culture. Clear? You can respect and love your language, force others to learn the language, beat them also. No, not here, in your neighboring state now. We have aggressive language lovers. So that's there. Number 2, so this is a clause which actually prevents reservation in government schools and colleges. Okay, this was a clause which the Supreme Court used in the Champakam Dorairajan case to cancel reservation, which was bypassed by the Parliament to make the First Amendment Act. So look at this. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste or language. Okay. So caste-based and religion-based reservation in government schools and colleges is not allowed. But Article 15 Clause 4 was added saying that notwithstanding anything mentioned in Article 29 Clause 2, the state can make special provisions for SCs, STs and SCBCs, socially and educationally backward classes. So that article exists bypassing this provision which does not allow discrimination on the grounds of religion or race or caste or language in government schools and colleges. Are you clear? Now this article makes no sense because we do allow for discrimination. Okay, that was the same story for Champakam Dorairajan. Champakam Dorairajan was a lady who had cleared the exam and who did not get the admission in Tamil Nadu, the Madras province, in the engineering college. Why? Because she was a Brahmin and there was a existing British times law which was called communal law, which allowed only 2 seats for Brahmins, 6 for non-Brahmins, 2 for SCs, 2 for Christians, 2 for Muslims, etc. So 2 seats were already filled. She was a Brahmin, she could not get the seat. She challenged the Madras government's order. How can you have reservation? How can you discriminate against me based on my caste? Then Supreme Court upheld her point of view and cancelled the existing order. But then the Parliament amended the Constitution, First Amendment Act, and provided for reservation in education. Are you clear? That has come through a series of interesting events. Then is Article 30, right of minorities to establish educational institutions. So all religious and linguistic minorities, please understand that in our constitution there is no definition of minority, but we do have 2 types of minorities. One is a religious minority. This is on a pan-India basis. You cannot claim minority status of religion based on your state. For example, go to Mizoram, go to Nagaland, Hindus are less than 10%. Hindus cannot claim minority status there. Why? Because religious minority tag is given on a country-wide basis. Okay? And there is no definition also. What is a minority? Who is a minority? So we follow the most lame definition that anybody less than 50%. So even if you are 49% minority. Most countries don't follow this. Most countries follow a 5% criteria. Some countries follow 10% criteria. Okay? Some countries follow religion-based criteria. Like France, it follows a religion-based criteria that any religious group which is other than the Catholic Christians, they are all minorities. Most of the countries, China, Pakistan also, USA, every such country follows a 5% criteria that if you're less than 5% or 10% criteria. If you're less than 10%, only then can you claim minority status. In India, there is no criteria as such. And normally we believe that the criteria is 50%. That is why Muslims, despite being 14%, are claiming minority status. But there is no benefit as such. Even if you claim the minority status, there is no benefit as such. Second is linguistic minority, language-based minority. Okay. Now, interestingly, this is on a state basis. Please remember, this means that Telugu-speaking people are a minority in Tamil Nadu. Okay. Hindi-speaking people are a minority in Kerala. Clear? So, language-based minorities are on a state-to-state basis. So, if here a Hindu-speaking group starts a school or college, that will be called a minority school or college. Clear? That is why we have in our country around 14,000 minority educational institutions. Most of them are not religion based, they are language based. So, all religious and linguistic minorities have a right to establish and administer their own schools and college. And this is also very important. Again, some fundamental right to property for such schools and colleges. If the state compulsorily acquires property from a minority-run educational institution, the compensation must be fair and not restrict their rights. So if the state wants to take away your minority school, college land, it has to give you compensation. It is mandatory. Are they clear? Though normally if the state takes your land, it must give you compensation under the Land Acquisition Act, but that compensation is not mandatory. The state can take away land sometimes and give you no money. Take a 5-star, go enjoy, that's it. Land gone. Because we cannot claim a fundamental right of property. But minority educational institutions and religious groups, these two groups still enjoy fundamental right to property in the country. This means if you take away their land, you have to compensate them adequately. And when you take away their land, it should not restrict their right. Their right is to run a school or college. So if that gets impacted, you can't take away their land. Clear? So some extra rights are given for these groups. Next is non-discriminatory state aid, meaning if the state wants to give aid, free money to various schools and colleges, it should give free money to every type of school or college, including those run by minorities, those run by majority, etc. You cannot differentiate. So the state cannot discriminate against minority managed educational institutions in granting financial aid. If you give money, please give money to everyone freely. Clear? That's it. Done with Article 30. Then just quickly, right to property exceptions. So we did have these two, is it mentioned there? Right? We have these two articles which used to exist earlier. Right to acquire, hold and dispose of property, Article 19, we saw that. And one Article 31. So this was one more right to property, that no person shall be deprived of his property, say by authority of law. Okay. So this was causing a problem because we wanted land redistribution. Remember, initially the land redistribution movement, etc. So, sorry? Bhudan was Vijayebhava's request to all the elite people that, please give your land. 4 lakh acres of land was promised. How much was given, we don't know. But otherwise, the government started a redistribution movement through law. But the biggest problem was these kind of articles. We could not take land from rich and give to poor. So then we made the first Amendment Act, because the problem is Article 13. Article 13 says that you can't make a law to take away fundamental rights. Remember, we saw that yesterday. And that becomes a direct problem because this is a fundamental right to property. Every citizen has a right to acquire, hold and sell property. You can't forcefully take their property. And you can't make a law to take away property. So if I want to take the hundreds of acres of land you have and give to poor, I can't do it. Because I can't make a law which violates fundamental rights. That is why an Amendment Act was passed. First Amendment Act was passed. A new article was added that state can make laws for acquisition of large estates. And if the state makes such laws, it can't be questioned on the ground of violation of fundamental rights. Clear? One more article was added, 31B. This said that we'll add one Schedule 9. And what is Schedule 9? If we make any law and we put it under Schedule 9, that law is immune from judicial review. But it was later on challenged after the Keshwan and Bharti judgment. Now this became a problem. Let's say today you make a law saying that India is no longer a democracy. Narendra Modi is a new king. Rahul Gandhi is a new prince, whatever. And then you make the law and put it in Schedule 9. then what do? It is directly violating basic structure. Democracy is a part of basic structure. So provision of court case was filed. Finally, in 2007, from 1970 the case was going on. In just 37 years, you know how fast our judiciary is anyway. In just 3-4 decades, judgment came, and here the Supreme Court said that, see, we respect Schedule 9, but all laws put inside Schedule 9 after the date of judgment of Keshwanan Bharti, which is 24th of April 1973. This is the Keshwanan Bharti judgment date. After this date, all laws put under Schedule 9 will be open to judicial review on one ground only, and that ground is violation of basic structure. So Schedule 9 still exists, it still has the immunity, but if you make a law and put it in Schedule 9, the courts can question it on only one ground. And what is that ground? Violation of basic structure. Are you clear? So that blanket immunity no longer exists. Case is important. They might ask you a question on this case. So please remember IR Coelho. Though this is more mains topic, in 2016 they asked a mains question on this. Done? Any doubt? No? Okay. Then we have one more thing. Article 31C. You know, the government was not happy yet with the provisions. They said that, okay, can you come to today's notes please and go to Article 39 on the second page. On the second page, it is mentioned. So please read clause B and clause C. Clause B roughly talks about, you know, we have to redistribute countries' resources to subserve common good of the country. And clause C talks about how our economic policy should be in such a fashion that it reduces the concentration of wealth in the hands of few people. Did you get it? 39B and C. So this Article 31C was added through this Amendment Act. Both are important. And it says that if any law is made to give effect to Article 39B and C, meaning if I want to make a law to redistribute countries' resources or reduce the concentration of wealth, right, then that law can also violate Article 14 and 19 and you can't question it. This means, in short, what we have done is 39B and C are given precedence over 14 and 19. Something like this. That Article 4, because see, if let's say I want to reduce the concentration of wealth, I want to today take money from Ambani's account and distribute to all of you sitting here. Nothing is being given, relax, okay. But if you want to make a law like this, Ambani can question, how dare you, Article 14 is getting violated, right to equality, right to property is getting violated for him. So the parliament said no, he cannot challenge it if it violates 14 and 19. So 14 and 19 can be sidelined if the purpose is to redistribute countries' resources, if the purpose is to reduce the concentration of wealth. Are you clear? This was Article 31C. Later on, in 1976, the government said that we can violate Article 14 and 19 for any DPSP. So they expanded the scope of this 31C to all the DPSPs. Court said no, this is not possible. There are so many DPSPs which are just useless DPSPs. We can't allow for that. If you allow that, then what is the value of 14 and 19? Right? So that part has been cancelled in the Mineral Mills case. Article remains, this provision remains. Are you clear so far? The extension of this article to cover all DPSPs has been struck down, but this still covers these two DPSPs. So this provision is still applicable. Okay. Now during emergency, one more article was added, 31D. It has been repealed now. It simply said that if you make any law to prevent anti-national activities, that law cannot be questioned on the grounds of judicial review. This has been repealed by the next Amendment Act. So nothing much to worry here. But remember that we had a 31D which was added through 42nd Amendment Act and repealed via 43rd. Okay. Lastly, all this drama was happening because of right to property. So when Janata Party was in power, it passed a 44th Amendment Act. This was repealed, and this article was made into a constitutional right. So think of it like this, that you have your constitution, there is part 3, under which you have one article 31(1). This article was taken from here and thrown inside here. That you don't enjoy fundamental right status now, you just enjoy a constitutional right status. Are we clear on this? Everyone, please read the article again. Which article has been shifted? 31(1). Read what is mentioned 31(1). So this, you can put a star mark here and also write dash now what? 300A. No person shall be deprived of his property save by authority of law. Please mention there, this is now become 300A. This is gone. This is gone. And don't cross it. Just remember it. Clear? Should we proceed now? Okay. Then we have Article 32, UPSC's newfound love is Article 32. Now they're asking questions from this back to back, right? We have had 2 questions now from this topic in the last 3-4 years. So this is what UPSC does. It takes a topic, falls in love with that, goes crazy, mints it for the next 3-4 years and then stops asking any question from that. So right now they're in the zone of asking from writs. Okay, we might expect the more question on writs in the coming years also. So Article 32 is issue of writs. What is the meaning of writ? Writ means order or directive given by the court. That's called writ. Writs, orders or directives. So Parliament by law can, firstly, who can issue writs? Supreme Court can issue writs for the protection of fundamental rights. High courts can issue writ for protection of fundamental rights and other matters also. So they can issue writs for protection of legal rights also. Supreme Court cannot issue writs for legal rights. It can only issue writs for fundamental rights. Are you clear? Just to remind you, writ of Supreme Court is in which article? 32. And High Court? Very good. High Court article is 226. Supreme Court article is 32. Don't be confused. So this is what was called by Ambedkar as the heart and soul of the Constitution. So Ambedkar says that, if you were to ask me what is one article which is without which the entire Constitution is a nullity, meaning null and void. Nobody is asking him anything. He just said on his own. Then he says, I cannot point to any other article but to Article 32, which is the heart of the Constitution, the very soul of it. So he has called this as the heart and the soul. You know how you call somebody, you are my heart, you are my soul. All the messages you send, same way. In the Constitution, Article 32 is the heart and soul. Now, why would you call this heart and soul? It's completely logical. He says, Ambedkar says that without this article, the entire Constitution is null and void. So for that, you have to understand what is the meaning of Constitution. Constitutional government means what? Limited government. That's the meaning of Constitution. Constitutional government, if you ever read this word, it simply means limited government. So the first purpose of a constitution is to limit the government, limit the state. Clear? And what limits the state? Fundamental rights. Fundamental rights are limitations on state. Clear? And which article protects the fundamental rights? 32. If you don't have Article 32, then nothing protects the fundamental rights. Then nothing limits the state. Then what's the point of the Constitution if it cannot limit the state? So he's coming from that angle. Okay, that's why heart and soul. Now, Supreme Court can currently issue writs only for protecting what? Fundamental rights. It can be increased by who? Parliament, by law. By law meaning simple majority. So please understand, if you want to increase the power or authority of Supreme Court, it can be done by law. But if you want to decrease the power of Supreme Court, it requires a special majority. Amendment, Article 368, and that also with the state's consent. Okay, if you look at the list of federal features that require amendment, with the state's consent, it also mentions Supreme Court and High Courts. So to decrease power of High Court, Supreme Court, special majority. Increase power, simple majority. Are you clear? Okay. And the same Parliament can also by law, meaning simple majority, empower any other court to issue writs. Other courts can also issue writs. Today, district courts can start issuing writs if the Parliament makes a law and allows them. Clear? Okay. Now we have 5 different types of writs. First one is habeas corpus. See, most of these writs do not require locus standi. You know what is locus standi? Locus standi means only affected person can go to court. That is called locus standi. This is a concept used in PIL. Okay. So what is a PIL? No. Full form, very good, excellent. Public interest litigation. PIL means a court case being filed where there is no need of locus standi. So to give you a simple understanding, if your house is robbed today, who will go and report to police? Somebody in Tripura? Of course not. You will go and report to police. So only affected person can approach the court. Okay, that is called locus standi. Only affected person can move to court. But it might not always be possible for only affected person to move to court. Okay, what if you don't know your rights? What if you're in jail? Say in your neighborhood there is some domestic violence happening. Husband beats the wife or wife beats the husband. Anything is possible. Now in that case, the husband or wife is too afraid to go to the police or report. Then who can go? You can also go and complain. Right? So this is what the courts have allowed. So we say that PIL simply dilutes locus standi, that any person can go to court. Same thing here. Locus standi is of no value. Any person can approach the court in all these writs. You don't have to be directly impacted. Are you clear? First is habeas corpus, to have the body of. So if at any point of time police arrests you and keeps you in lockup without authority, then your friend or family members can go to court and ask the court to issue a writ of what? Habeas corpus. Then the court will order the police to present you in the court. And then the court can ask the police, why have you arrested this fellow? What has he done, etc. He's an honest, innocent aspirant only, whatever. Are you clear? That's the idea that habeas corpus uses. And it can be secured as a matter of right. This means courts can't refuse it. Court cannot refuse. If you today go to the court to claim habeas corpus, the court cannot refuse habeas corpus. It has to issue the order because somebody is being held against their will. Okay? That's important. Also, it can be used against public and private bodies both. So let's say your parents hold you against your will in the house. This might happen in future. If you fall in love with somebody outside your caste or religion, then your parents will lock you up in the room. Okay, then the other person, if you are the lover, you can approach the court. Ask the court, please issue writ of habeas corpus against that father. How dare he hold him or her against the will? Then the court will issue a writ to the father that please bring the person in the court. Clear? When the person comes, they might say, who are you? Who is this fellow? It might happen. That's about your love and the bond that you share. But you can use this in future. Okay, if this happens at any point of time in future, you can use this. But a better way would be clear the exam, nobody will stop your marriage. Today's motivation. Okay, so this is how habeas corpus can be used against public and private bodies. Second is mandamus. Mandamus can be used only against public bodies. or any such body which performs public functions. Plus, write like this, plus private bodies performing public functions. Private bodies performing public functions. Okay. So this is what is mandamus. Let's say a government official is not fulfilling their obligations properly. You go to a government office, these great banks that you have, let's say, and the bank insists lunch break, always lunch break, network failure. These, let's not name any bank, you know very well who we are talking about. So most of these government banks, nowadays the life is not that easy, but 10 years back they have enjoyed too much. So now there's too much of pressure on them to work. So anyway, if the person is not performing their task properly, you can go to court, get a writ of mandamus. But this can be refused actually. What if the department has less staff, shortage of staff, etc. This can be refused. This can't be refused. So you can get this mandamus issued against government officials or any person who is performing some government function. For example, all these people who get the government contract to build a road, bridge, you can get a mandamus issued against them also. But why is the bridge not being built? You can't get this issued against private people. Like, why is my father not giving me a new mobile phone? Go to court, mandamus against him. Can't issue that. Court will scold you, you come back home, your father will beat you also. So don't take this risk. Now, mandamus cannot be used against the president or governor that please sign the bill. No, we can't do that. Also, plus legislatures. You can't get this writ issued against the parliament that pass a law on this matter. That can't be done. But otherwise, it's all allowed. This is mandamus. Then next is prohibition. Prohibition and certiorari are used in court system only, meaning higher court gives order to lower court. So prohibition is a case where, a lower court, if it tries to cross its boundary, exceed its jurisdiction. For example, let's say something as simple as, in our country, constitution and rights can be interpreted only by the constitutional courts, meaning High Court and Supreme Court. Lower courts cannot interpret the constitution. What if such a case is filed in the lower court? A lot of people go to court to interpret Article 21 for very weird kind of things. Okay, so we saw yesterday Article 21, it means so many things, such a wide interpretation. Few years back, one person had gone to the court saying that, when I go to work, the boss harasses me, colleagues don't talk to me properly, my life in a workplace is very bad. And every evening I come back home, I open a bottle of whiskey and I drink a couple of pegs and I sit back and relax and I forget all the worldly problems that I experience. So he said, court, please interpret Article 21 to also include right to drink and forget worldly problems. This was an official court petition. The right to drink and forget worldly problems as a part of Article 21. Court said leave immediately. No, but the point is that, let's say this kind of, so for your UPSC aspirants, you are suffering right now and somewhere you read that smoking marijuana can help you retain a lot of information. So there's some study being done, don't start smoking immediately. But marijuana can be of some help in diabetes and certain kind of diseases, okay. So let's say you feel that, by smoking marijuana you feel more relaxed, etc. Exam tension goes away. Ganja. And then you go to the lower court. Because you have no knowledge, of course you'll go to lower court only. You file a case there. Now, such a case cannot be filed in lower court. Because interpreting Article 21 can only be done by High Court or Supreme Court. If this happens, then the higher court gets the information that in a lower court a case is filed, which is beyond their authority. Then the higher court will issue an order to lower court that don't take up that case. That is beyond your authority. That is called prohibition. Clear? If the lower court takes up the case, the judge is also like you only, he is waiting for such a case. He takes up the case. Then again the higher court will issue order to lower court. How dare you take up the case? Give the case to me, I will decide. That's called certiorari. Certiorari. Or if the lower court not only takes up the case, it gives a judgment also. That yes, you are right, smoking ganja is a part of Article 20 and both of you start smoking there only. So in such a case, the higher court will cancel the judgment and transfer the case to itself. Are you clear? So right from filing of case to accepting the case to judgments, the lower court, if at any point of time takes up any matter beyond its authority, the higher court can issue a writ of prohibition or certiorari. Okay? Now, these are meant only in the court systems, but since 1991, certiorari can be used in administrative proceedings. To give you a simple example, if let's say your senior transfers you, okay, but if your senior is not authorized to transfer you, then you can go to the court and claim this certiorari that the senior was not authorized to transfer me, remove me, whatever. Okay, he is exceeding his authority. So this since 91 has been allowed in the administrative cases proceedings also, but prohibition is only meant for court proceedings. Done? And lastly, quo warranto. By what authority? So this is a very simple kind of writ. For example, people always go to court for raga. You know raga? The innocent, honest bachelor of our country, the king of vote chori, Rahul Gandhi. So there is a confusion about his citizenship. So when he contests elections, so only citizens can contest elections. Now people file a petition in court saying that whether he has won the election or not, that is of no concern. He was not eligible to contest elections. Ask him to prove his citizenship. So you go to court challenging the claim of a person occupying public office. If Raga cannot prove the documents, then the court can remove him from post. If he proves that he is a citizen, then end of story. Are you clear? So this quo warranto is largely used in reservation matters. Okay. So I think in your state, I'm not sure what is the case here, but in Uttarakhand, there was a situation where a lot of these people took part in the Uttaranchal or Uttarakhand separation movement. So reservation was given for them. And even those people who had never taken part in the movement, they were claiming that I have taken part in the movement. And they would get the certificate. So people would go to court and challenge it that this fellow was not even living in Uttarakhand. How dare he take part in the movement? Okay, that becomes a problem. Or I think I was discussing about this Pooja Chaudhary case. No, what is it? What is it, girls? I forgot the name again. Purva only. Purva Chaudhary. So Purva Chaudhary case. Now what has happened in her case is that she supposedly does not seem to be from the economically weaker section category. You can file a petition in the court and ask her to prove her documents. Are you clear? So if at any point of time your friends clear the exam and you don't, and they are on some certificate, you harass them by filing case in court and then ask them to prove the certificate. Because you know very well, they are your friend, you know if they are rich or poor. Okay. They were rich, enjoying life, and suddenly they get a income certificate from somewhere, circle officer to bribe the circle officer, then you know very well, so you can complain. Okay. No, don't use all this. Focus on your own studies. If possible, you get your own fake certificate. Ask him, where did you get the certificate from? So this is called quo warranto. Again, as I said, you can also approach the court and seek a quo warranto. Locus standi is not required. You might not be the affected person. Anybody can approach the court. Are we clear? End of story. This brings us to an end of our fundamental rights. Couple of small things remain. For example, your fundamental rights can be modified in their application to certain kind of services. Like we have Army Act, Navy Act, Air Force Act, and all those who want to become IPS officers to harass your neighbors, Police Force Restriction of Rights Act. People who are in these services, you don't get to enjoy all the fundamental rights, okay? For example, a few years back, there was a case when one BSF Jawan, he was too inspired by TikTok generation and made video of the BSF canteen food and then made fun of the canteen food. That is not allowed. He was dismissed from service. You can't protest like this. Okay, this ensures discipline. Clear? See, we saw yesterday you have right to sleep under Article 21. Yes or no? Don't use it in the class. Now imagine your army head tells you, come on, go and kill Pakistanis. You say, no, right to sleep, Article 21 right now. That could be a problem. That is why these people might not be allowed to enjoy all the fundamental rights. Their rights can be modified. Number two, if martial law is enforced, what is martial law? Military rule is enforced in the country, then your fundamental rights may be suspended. But please understand, whatever happens, habeas corpus is never suspended. Okay, Article 21 can never be suspended in any circumstance in the country, including emergency, including martial law. Okay, habeas corpus can never be suspended, and also we are yet to implement martial law in the country. It has never been implemented. In the British time, it has been Paca Rebellion and First War of Independence, etc. But otherwise, it has never been implemented. Lastly, in our fundamental rights, we saw various places where this word by law was mentioned. For example, Parliament can make laws for reservation based on residence, or untouchability is an offence and is punishable by law. Such things. Who can make a law on that? Centre or state? So Article 35 says that only Parliament can make laws and states cannot make laws on these matters. Number one, this one. Number two, empowering other courts to issue writs. Number three, Article 33. That is what? Modifying your application of fundamental rights. Number four, Article 34, which is what? Martial law. Number five, punishment for untouchability. And number six, punishment for traffic in human beings and forced labor. Are you clear? Please remember these. Only your Parliament can make laws on these things. States cannot make laws. Done. Quickly to summarize the nature of our rights. Most rights are available against the state, some against other people also. For example, untouchability. State will not practice untouchability. Other people practice untouchability. So some fundamental rights are against the state, others are against the people. Next, most rights are negative obligations, meaning they are limitations on state. When I say negative obligation, I mean to say limitation on state. State shall not discriminate against any citizen, right? On the ground of RRCSP, religion, race, caste, sex, place of birth. Remember, article, which article is this? 15. But sometimes some rights are positive in nature. Give me one right which is positive in nature. Right to education, Article 21A. State shall take steps to provide education. Okay. Some rights are negative, some rights are positive. Then some rights are self-executory. They can execute on their own, like freedom of speech, etc. Some require a supplementary law. For example, untouchability. When you say untouchability is an offense, it will be punishable by law. Where is the law? You have to make a law. And then Parliament made a law. Or when you say, kids now you can go to school, but where? How? What is the process? So to enjoy this right, you have to make a law. Only then can the kids enjoy this right of education. Clear? So those rights which require law are called non-self-executory. Those rights which don't need a law, they are called self-executory. They execute on their own. Clear? Then, very important, all the fundamental rights are justiciable, meaning you can go to court and claim the fundamental rights. In our country, rights are not absolute. We are not living in USA. Okay, in our country, rights are restricted. Reasonable restrictions can be imposed on our fundamental rights. So you can never claim absolute fundamental right. We saw very well, rights are there, hundreds of restrictions are on there. Okay. So in our country, you cannot, as a mark of protest, burn the national flag. In US, you can burn the national flag. as a mark of protest. In our country, it's unthinkable, right? Then some rights are meant only for citizens, which 15, 16, 19, 29, 30 meant only for Indian citizens. Then fundamental rights can be suspended during national emergency. We'll discuss them during emergency provision. Then they can be modified in their application to special services by law, which is Article 33, Army, Navy, Police, etc. And lastly, very important, fundamental rights are amendable. Rights can be amended. Okay? Using Article 360, you can amend the fundamental rights. Clear? That's it. End of story on fundamental rights. Now, before we move on to our next topic, firstly, start by solving some questions. Okay, Atharv, prohibition and certiorari. Oh, prohibition means the higher court gives the order to lower court for what? To not take up a matter. Why? Because that case is beyond its authority, prohibiting the lower court from exceeding its power. But if the lower court accepts the case, then we can't prohibit them now because case has been accepted. Then use a different kind of writ called certiorari, that please don't give a judgment. Or if a judgment is given, then again the writ of certiorari is used, that your judgment is cancelled, give the case to me, I will decide. That is called certiorari. I hope this point is clear. If not, please let me know. And yes, answer please. C. Any other answer? So rights are claims of state is stupid. Rights are privileges of few citizens is wrong. Rights are privileges. So firstly, rights are not some privileges given by the king or queen. Rights are your entitlements. Okay, always remember this. Privilege is something bestowed on the goodwill of the government. Rights are entitlements. You are entitled to these rights. So rights are claims of the citizens against the state. Right answer is C. Okay. I think, Ankita, we have the answer now. Rights are not privileges, rights are claims, and not all rights can be a part of the constitution. Some rights might not be part of the constitution also. Okay, a question asked. We should not have put it here, but maybe can you take a guess? You can still solve it. What's the answer? So in your question yesterday, notes yesterday, Article 13, law cannot be made to take away fundamental rights. Yes or no? And law includes what? Ordinances also. So ordinance cannot abridge a fundamental right. These can be abridged only by which article? 368, not through ordinance. So remove 2. If you remove 2, then using the great YouTube elimination technique, you get the answer. 1 and 3 only. Are we clear? So ordinances can abridge a fundamental right is wrong. Ordinances cannot abridge a fundamental right. Okay, simple question. Shiva, Rajkiran, Ankita, I think you need to check on that. Refer to your notes, Article 13, it's mentioned there. Yes. Rule of law. See? Okay. So rule of law means, of course, equality before law, limitation on state, liberty, civil rights, people's responsibility to the government. No, that's wrong. So 1, 2 and 4, right answer is C. Okay. What is limitation on state? Limitation on state. Rule of law, we just saw that. Rule of law. If any law creates unlimited power for the state, it violates which article? Article 14. Because Article 14 means limitations on the state. If you give the state an unguided, uncontrolled, discretionary kind of power, then you are actually violating Article 14, because Article 14 means what? Limitations. Are you clear? So right answer is A, Article 14. Is it clear to everyone? Doubt? Limitation of power, Article 14. If you make a law which says that state has no limit, unguided, uncontrolled power, this means you are violating Article 14. This one. Who declares the category of scheduled tribes and all? President. So President will declare, and the list is released by the President. Any modifications in the list is made by Parliament when it comes to scheduled castes and scheduled tribes. For OBC, states can have their own list. So correct, it is the governor of the state who, wrong, it is the president of the state, president of the country, who recognizes and declares any community of the state as a scheduled tribe. Okay. And number two, a community declared as a scheduled tribe in a state not be so in another state. Is it correct? Yes, of course. You can be an ST in the state, you cannot be an ST in the other state. It is possible. Yes or no? SC, STs are, so there is an order called Constitution SC Order 1950. Those who have covered this can refer to the notes, you will get to know. And then we have a Constitution ST Order, same 1950. Okay. In this particular order, you have all the names of states and the various tribal groups of that state, various SC communities of the state. So it is possible that you belong to a state and you might not be so in some other state. Okay, that's the idea. So a community declared as a scheduled tribe in a state not be so in another state. Clear? Should you proceed? Any doubt here? Confusion? Need explanation? Okay, we have the answer B and some of you mark D. Now this question, see, I'll tell you a simple funda before you solve this. In polity, so far in the last 25-30 years, any of these kind of two statement assertion reason questions, the answer has always been one statement is wrong. In polity, this has been the case so far. So when you look at a polity question like this, please try to find out which statement is wrong. And you can get the answer as C or D, always. What's the answer? C. Article 335 defines, so we saw this yesterday, the efficiency of administration argument, which the Parliament modified to say that we can lower the qualifying marks, remember? So, and in most cases, things are not defined in the Constitution, so don't have to worry on that also. Clear? So 2 is wrong, this means statement 2 is incorrect, this means C is the right answer. Efficiency of administration, okay Shiva, correct. One more easy question. Untouchability, which article? Article 17. Article 17 is under which category? Right to equality. Don't put exploitation, because exploitation is child labor and all. Okay? So right to equality. Bharat Ratna and Padma awards are titles. Are they titles? Yes or no? No, we saw it yesterday that these awards are not titles. Padma Awards, which were instituted in 1954, is correct. Were suspended how many times? Twice. Okay. The number of Bharat Ratna awards is limited to maximum how many?
3.
What's the answer? Very good. Excellent. Okay. So firstly read the question and then solve accordingly. Okay. Very challenging question. Right to privacy. Which judgment? Putta Swami case. So Article 21. Okay. Look at this question. Again, right to privacy. What's the answer? C. Right? Again, right to privacy. UPSC is obsessed with right to privacy. What's the answer? Again, C. Article 21. Okay, yes, very good. Article 21. And now solve this. Right to marry a person of your choice. Article 21, Hadia case. This was that, infamously called the love jihad case. The Hadia case. Okay. Sometimes, we have some slightly challenging questions also. What is due process? This is wrong. This is Article 14, rule of law. Fair application of law means the law is applied in a fair manner, which means this only. Procedure is established properly. Yes or no? Fairness. The idea of due process means the idea of fairness. Principles of natural justice. Nema causa in judex sua, audi alteram partem. Those are the principles of natural justice. Okay. Then so right against exploitation. First one, which article is this? 23. Which article is this? Which article is this? And number 4? 24. Right against exploitation, 23 and 24. Right answer is C. 1 and 4 only. Yes, absolutely correct. All of you. Great. Very good. Which one of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of fundamental rights? What's the answer? A, B, C and D, anyone? No? So 86th Amendment is the right to education thing. Let's eliminate this. In the ADM Jabalpur case, Supreme Court said that even Article 20 and 21, right to life, can be suspended. Yes or no? Remember, very popular case. And in the 44th Amendment Act, amendment was made to provide that exception. Okay? Reinterpreting the Supreme Court judgment. Also, the Supreme Court had given the basic structure doctrine. In the 42nd Amendment Act, the Parliament modified Article 368 to say that, there is no limit on the power of Parliament to amend, which was cancelled later on. Possible. Also, the land redistribution provisions and the reservation in education provisions which were passed, First Amendment was brought to change that also. So what's the answer? This question was cancelled by Supreme Court, UPSC. The answer key had a dash. Because 1, A, B and C are all correct actually. Okay. So sadly, this question was cancelled. None of you are correct or wrong. A. D. Okay, what is the current position of right to property? Which article became right to property? No. Which article became right to property right now? 31 clause 1 became article 300 capital A. This article is now 300A. Read this article. Read it. What does it say? No person, not citizen. No person shall be or deprived of his property. Yes or no? So, right to property is now a legal right, of course, because it is a part of the constitution, some legal right, and is available to any person, not citizens only. Are we clear? So, the confusion is that please understand which article became 300A, and then you can get to know. Because the right of citizens to property has actually been repealed. That is why. Is this point clear? Any doubt here? No doubt? B. Okay. Yes. Writ of prohibition. Lower court prohibiting the continuation of proceedings in a case. Okay, very good. C is the right answer. Great. C. Okay, let's see. Mandamus will not lie against a private organization unless it is entrusted with public duty. Yes or no? Is correct. Mandamus will not lie against a company even though it's a government company. If it's a government company, we can have mandamus against it. 2 is wrong. Remove 2, and shortcut techniques to clear exam. You get the answer. Third one, any public-minded person can be a petitioner to move to the court to obtain writ of court. Yes or no? No locus standi. Anybody can move to court. So this is anyway correct. Okay, that's it. Now let's come to DPSPs. So the problem with DPSP is that you have to remember some provisions. Roughly, you need to remember DPSP articles. Otherwise, there could be a huge problem in solving questions. First up, it is under part 4. Okay, articles 36 to 51. Influences, please remember, Irish Constitution, Government of India Act, Tej Bahadur Sapru Committee report, and socialistic, Gandhian and liberal principles are also there. This is not divided in the constitution. This is based on our understanding. Some principles are called socialistic in nature, which talk about equality, wealth redistribution and all. Some of them are Gandhian in nature. Village economy, panchayats, cooperatives, don't drink, don't kill, all those nice things. And liberal principles, UCC, education, taking care of wildlife, national monuments, etc. They're all liberal principles. International peace. We'll see that shortly. Definition of state, because it is directive principles of state policy. So state definition, same as Article 12. Okay. See, in the Irish Constitution, they also have the same thing called DPSP, but it is called directive principles of social policy. So we have drawn inspiration from there, and we have changed it completely. From directive principles of social, we have made it to state policy, so that nobody gets to know also from where we have taken it. Okay, this article is important. Please remember, This article tells us the importance of DPSP and also that DPSP is non-justiciable in nature. Meaning, whatever principles are mentioned here, you can't claim them in court. The provisions contained in this part, which part? Part 4, shall not be enforceable by any court. So, fundamental rights are enforceable, DPSPs are not enforceable. Now, if you read this, you will say, then what is the point of all this DPSP? The article says, but don't start crying immediately. But the principles therein laid down are nevertheless fundamental. So, not be enforceable by any court and fundamental in the governance of the country. Fundamental in the governance of the country. Clear? And it shall be the duty of the state to apply these principles. When you make laws, the state has a what duty? Moral, legal, that we don't know. But a duty to apply these principles. So don't think of them as some general kind of ideas. Even though we can't claim them in court, they are fundamental in the governance of the country. And the entire concept of DPSP is to provide for India as a welfare state. What is meant by welfare state? Any state which protects and promotes the social and economic well-being of its people is called a welfare state. So, protection and promotion of social and economic well-being of people. This is the meaning of welfare state. DPSP talks about India as a welfare state. Are you clear? Okay. Now our only task is to go through all the DPSPs. So, of course, you can't mug up the DPSPs. This is where I have created the bifurcation. You can just cross-check it through your articles. You'll get to know. Any article that deals with creating equality, etc., financial, economic angle, that is a socialist article. If it talks about cooperatives and not killing, not drinking, all those great things, Gandhian, and modern principles, liberal. Are you clear? Everyone? Okay. So, as I said, difficult to remember all these articles, but the crux should be remembered, that it is roughly there. So, Article 38 talks about how the state shall strive to promote welfare of the people, and underline this phrase, justice, social, economic and political. This phrase is also mentioned somewhere else. It's also mentioned in the preamble. Okay. Just circle the second clause. I'll tell you why I have made you circle it, don't worry. So, state shall also in particular strive to minimize inequalities in income, endeavor to eliminate inequality in status, facility, opportunity, etc. So, there should be no inequality in the country. That's not possible, right? That is why these things are not justiciable in nature. Because if you have it justiciable, then you will go to court immediately, saying, I want same status, I want equality as Ambani. That's not possible. Ambani is Ambani. Clear? Then we have Article 39. These 6 things are there in Article 39. Put a star mark on the last clause. Why? I'll let you know later on. Okay. So, the state shall in particular ensure that citizens, men and women, equally have right to adequate means of livelihood. We'll have to go through these. Remember roughly what is mentioned there. I think B and C are some things we saw right now. The control of resources should be distributed properly, reduce concentration of wealth. These 2 articles are superior to which 2 fundamental rights? 14 and 19. Okay. Then there should be equal pay for both women, men and women, equal pay for equal work. Then health and strength of citizens, men and women, tender area of children should not be abused, and citizens should not be forced by economic necessity to enter avocation. Avocation means profession. So nobody should be forced to work because of what reasons? Economic reasons. Why do you work? For economic reasons only. But the article says that nobody should be forced to work for economic reasons. Right? This is a high sounding concept. This means follow your passion. If every person starts following passion, then who will do the difficult task? So that is why these are not justiciable in nature. Okay? So see, they say that there is a group of people who don't like their job. That group is called everybody. Okay? Nobody wants to work, sadly. But the article says that no, nobody should be forced to work because of money. Work because you are passionate. Imagine today the passion funda comes out, passion bill 2026. Work only for passion, no salary. Of course, a lot of people will not work. So high sounding ideals, not really practical and realistic in nature. Then we have the sixth one, children are given opportunities and facilities to develop in a healthy manner, and all that nonsense is mentioned. Then 39A, equal justice and free legal aid. Do we have something for this? Have we achieved this? We have the NALSA, SALSA, DALSA, TLSC, the entire structure in the country. Then Article 40, have you achieved that? Gandhian article? Amendment Act, tell me. 73rd Amendment Act, 1992. Okay. Then provision for just and humane conditions of work. Just and humane conditions of work. It was mentioned here itself, right? Okay, that the health and strength of workers should not be abused. Just conditions of work have to be provided. Strange repetition. Then Article 41, right to work. Again, see here. All citizens have right to adequate means of livelihood. Now they have changed the word and they are saying right to work. Okay, they know only one point. Like UPSC aspirants answer. Only 2 points, 250 word answer. What to do? Same point again and again. Different words. So right to work and all is mentioned here. Then living wage. Now this article is a very interesting article because it says that state shall endeavor means strive, take effort to secure by suitable laws or economic organization or any other way to all the workers, agricultural, industrial or otherwise work. Again right to work, shamelessly third time. A living wage, and look at this, conditions of work ensuring decent standard of life and full enjoyment of leisure. It is a duty of state that we enjoy our leisure. How can this be enforced in court? That is why non-justiciable, high sounding principles. And imagine Indira Gandhi government wanted to change this, that all these are superior to Article 14 and 19. So how to ensure enjoyment of leisure? You go to court and say, come on judge, dance for me, I want leisure. Problem. That is why non-justiciable. Then 43A, participation of workers in the management of industries and promotion of cooperative societies, these two. So although with capital letters are all later additions, I'll show them where. Then you have Article 44, dangerous article, UCC, Uniform Civil Code, we know very well. Question has been asked in mains on that. Article 45, ECCE, right, 0 to 6 years. Article 46, this is for the promotion of the weaker sections like SCs and STs. Okay, so all the reservation policies which we have, NCSC, NCST, NCBC, they're all to promote this article only. Then again Article 47, this is again an article which goes against all the people who are fans of drinking here, because this article says prohibition of the consumption except for medicinal purposes, cough syrup, of intoxicating drinks and of drugs which are injurious to health. So this is the no drinking article, because Gandhiji hated drinking, so he put this article there. So no drinking now, right? And Gujarat has become what? Dry state. Dry state means where there is no liquor sold. They are suffering. That's why they make pineapple pizza and Oreo Maggie. You have to get high from somewhere, right? So Oreo Maggie is being sold there. Please visit and try Oreo Maggie at your own risk. Okay. No, they have raspberry Maggie, Oreo. At some point of time, I think Maggie should have some human rights also. This is wrong. And if you remember, a few years back, we were saying that Maggie has lead in it. We can't eat Maggie. We can eat Oreo Maggie. That's a bigger offense. But anyway. Then 48, this is the beef ban article. Why? Because this article says prohibiting the slaughter of cows and calves and other milch and what is milch animal? Milk producing which are fit for human consumption. A lot of animals give milk, but some which are fit for human consumption are milch cattle like cows, buffaloes, goats, camels, donkeys. That's it, I think, that's it. No other animal. Draught cattle, beasts of burden, right? UPSC aspirant, sorry. Oxen, donkeys, horses, camel, draught cattle. Are we clear? Okay. Then 48A is the protection of and improvement of environment, etc. 49 is for the monuments and places and objects of national importance. So it is the obligation of the state to protect these environments, protect these monuments. Then 50 is separation of judiciary from executive. And 51 is promotion of international peace and security. That is why we never fight with any neighbor, including Bangladesh. We let them harass us. Why? Because DPSP, Article 51. What can you do? Encourage settlement of international disputes by arbitration peacefully. That's the idea. Now what you need to remember is this very important. DPSP was amended 4 times. The first was 42nd Amendment Act, where 4 changes are made. 3 articles were added and Article 39, which you had put a star mark on, the last clause, F, second part, this part has been added later on. Okay. 42nd Amendment Act 1976. Are you clear? Everyone? Okay, great. Then again let's go. So second is the 44th Amendment Act 1978. Article 3, you have circled the clause. That clause was added in this Amendment Act. So coming to Article 38, this one, through the 44th of the year 78. 44th Amendment Act 1978. Second clause. Okay. So first change was made in 1976, where 4 different changes were made. Second amendment was passed in 1978, 1 clause was added. Done. Third amendment was 86th Amendment Act, where 1 subject matter was changed. And fourth was the 97th one, where 1 more Article 43B has been added, cooperative societies. The same amendment has also made a change in fundamental rights. Remember, Article 19, right to form associations, unions and cooperative societies. That part is added through this same Amendment Act. So please remember roughly all these provisions as well as the amendment. Clear? What changes were made in what amendments? Important. We have had a question from this in the previous exam. And lastly, fundamental duties. Remember, number 1, this is part 4A, only 1 article, 51 capital A. It has 11 clauses. These are all 11 clauses. Last clause was added later on. We know very well, 86th Amendment Act. And this fundamental duty, it has been inspired by Soviet Union. On the very first day we had seen sources. And also there was a committee called Sardar Swan Singh Committee, which gave recommendation for fundamental duties to be added. Okay. The same Sardar Swan Singh Committee also gave 1 more recommendation, tribunals to be added. Okay, we'll study that later on. So, and also these duties are meant only for who? Citizens, never forget, only meant for citizens. These duties are non-enforceable. Are you clear? So, we have to abide by the constitution and respect its ideals and institutions. We should cherish and follow the noble ideals that inspire the national struggle for freedom. We should uphold and protect the sovereignty, unity, integrity of India. We should defend the country and render national service when we are called fight. Then promoting harmony and spirit of common brotherhood amongst all the people, transcending religious lines, linguistic lines, regional diversities, and to renounce practices derogatory to the dignity of women. Okay. So like, if some woman is wearing a burqa, snatch her burqa. Or if some woman is wearing a sari, snatch her sari. Karnataka CM, you saw the video? So, renouncing the practices derogatory to women by our politicians, lead by example, harass women. Then, to value and preserve the rich heritage of the country's composite culture. So, we have very composite culture, value and preserve that heritage, okay, of untouchability, of triple talaq, all, no, of course not these things, nice things, right? Then, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Okay, so just don't like the cute kitten videos, don't throw stones on dogs on the road, etc. Don't tie crackers on their tail in the festivals, respecting animals also. Then to develop scientific temper, humanism, spirit of inquiry and reform. Okay, developing scientific temper. We just today saw Article 25, right, to practice your ritual and religion. At the same time, you have to also follow scientific temper and spirit of inquiry. So ask questions. So today go home, ask your question to your parents, then you will get to know. Scientific inquiry. 2 slaps and all duties will come out immediately. So these are meant only for class, okay? Don't take them seriously. Then to safeguard public property and to abjure violence, no fighting. Safeguard public property. Don't take it home, public property. Just safeguard it there only. Don't steal the bridges, roads, etc. Then to strive towards excellence in all spheres of individual and collective activity. So whatever you do, you strive towards excellence. Why? Because a nation is waiting to rise. So that nation can constantly rise to higher levels. So if you don't work, nation will not rise. Clear? So don't waste time watching Netflix and all. Strive towards excellence. And lastly, if you have some ward or child, please send them to school so that they have better opportunities in life than UPSC, than other things. Okay. That's it. Remember these duties roughly, not of course by hearting it. It's not possible because we do sometimes get questions. We'll be solving these questions on our next class. Okay. So let's end our discussion here only. Please go through all the DPSPs and the fundamental duties. We'll solve the question in the next class, and the next class we'll discuss executive. So President, VP, PM, Council of Ministers and Attorney General, all 5 to be covered. So now you can revise properly. I know tomorrow is Christmas, etc. You want to celebrate, enjoy. Enjoyment is not a word in the aspirant's dictionary. Suffering is the word. So just suffer. Okay. Okay, that's all for me guys. Jai Hind. If you have any doubt, let me know. Online people, any issue, concern, let me know. Doubt please. No doubt? Okay. You can leave, no problem.